So if I can, I just want to quickly talk about the importance of a childcare order. Right now, a childcare order, if you're unaware, is essentially an order which is provided by the courts and protected by the courts, and therefore enforceable by the courts. An order which essentially provides a parent with responsibility for the child or the children. And the reason why that's important is because responsibility goes into things like care, obviously where they stay, health, appointments, issues. It's also like notification of these things from government bodies, from the school, you name it. As far as it concerns children, it means you will be essentially contacted, you will be notified, next of kin, all of that stuff. And what that means is if you are a parent without that, and if you are particularly a parent without that, and you are having conflict with the other parent of the child or children, then your rights, essentially, whilst they are still applicable, they aren't necessarily going to be enforceable. So what that means is, although yes, you are the parent of those children, and yes, you have every right to parent those children and to care for those children and have them with you, without that order in place, it just means that there isn't anything to necessarily protect that time, protect that parenthood, if you like. So the reason why I think it's so important, and let me just start this by also saying, this can be to do with the parent's relationship, the co-parenting relationship that you have with your ex-partner. Because obviously if that's on great terms, and this may not necessarily be something that you want to put into place, but I still feel that it has a place even amongst those that are getting along. It could be considered very much like a prenup, in that if you are absolutely civil and you're getting along, then there is absolutely no reason to have this implemented, anything inside this document actually implemented, because you're just agreeable and you're getting along. Now, what it protects, of course, is if there is a disagreement. So if something comes up where now you guys simply can't agree, which admittedly happens quite frequently. So if you find yourself in a situation with your ex where you guys can't agree, and now one of you is just doing what you please versus the other one's arguments and, disliking of whatever this is, there's very little you can do to kind of prevent that or protect that from happening, other than, get into more arguments and maybe, introduce other, there's just a lot that you can kind of stir up and try to do, but there's very little you can actually do to enforce your right to have a say. And so even whilst there are certain things which can pop up, I suppose, with an order in place, what the order does is it's designed to kind of cover most aspects of parenting. Now, it's designed, I think, if written correctly, it's designed to do that, allowing you both flexibility within it, but also when it comes to important things and things which either come up on a frequent basis or come up on a annual basis, like birthdays or going to school, for example, which happens every day versus once a year. What it can do is it can give you absolute clarity about what's supposed to happen on those occasions. Now, obviously, when having one of these things written up, particularly in a court, you have to kind of get to a point where you are both somewhat in agreement of what this document says. Now, that's not always the case, because a judge or a magistrate will rule on this regardless of you guys, because that's kind of the point to a certain extent. It's also like, whilst you guys could have agreed to get to this place, this type of procedure and this type of order is also used for parents that absolutely cannot agree. That's its design, because what it does is it takes out the need to argue, it takes out the disagreement, essentially, because now it's written in an order. Whether you agree with it or not, you essentially have to live with it. Now, if you don't agree with it, you can still technically appeal that order, or you can, try to get back into court and have it changed, or solicitors involved, or even just speak to your partner about having changes made. Of course, if you are at the point where you're absolutely not in agreement whatsoever, then that's going to be very, very difficult. But the point is that it goes both ways. So the things that you might find difficult to live with, you know, your ex might have issues with things that are difficult to live with, but they protect the children and they protect your time for the prescribed time. Now, what that means again is that in my case, the order protects the children up until they're adults, because my children are very young. But obviously, these things can also be prescribed if there are going to be big changes in place. For example, if you are about to accept a job on the other side of the world, and you haven't done that yet, but you know it's likely to happen in the next, let's say, 2 years or so, then you would know immediately that an order that, you know, for young children that prescribes till they're adults is not going to be sufficient. So that particular order might survive until they're 18. Sorry, until the 2 years are done, until you then move, and then you might need another one to be put in place. But the point is that, in my opinion, the importance of this document is that it protects you. My order protects me as much as it protects my ex. And what that means is that when it comes to things like, for example, my time with the children, which is the fundamental basis of the order, but in terms of when I collect them from school, when I drop them off to school, when I have them for the weekends, etc., the order has written that out, so there can be no question as to when is my time. And whilst the order doesn't give, like, for example, it doesn't say, you know, January the 13th will be your day with the children, what it's done is it's put us in a routine where we can look forward. So we're now in a 2-week schedule. It's 50-50, so it's 1 week on, 1 week, not 1 week on, 1 week off. It basically varies over 2 weeks. So 1 week includes 3 nights, the other week includes 4 nights, so it's 7 nights over 14. So where we are now is that order is protecting all of those collection points, those times. And again, while it doesn't prescribe the actual dates, it means that because we're in this 2-week routine, when we get to things like end of term, half terms, birthdays, holidays, etc., we work around where we currently are, if that makes sense. So it's really easy. So it's not over prescriptive. It doesn't hold us down to dates in the future that we can't predict. But what it does is it just enables me to go, right, I can pretty much look at the next at least 6 months and go, this is my time with the children. And again, what that means is that when things come up like birthdays in my family, or special occasions, whatever, it means that if I can look at the diary and I see that, let's say I'm invited to a wedding and the children are welcome to come, and I look in the diary and I've got the girls that weekend or that day, wonderful, no questions asked, we're all going. If I haven't, and it's not my day, and we were totally uncivil, then that's just what it is. It's really unfortunate, and if there's a way that my family can move things around, then fantastic, but if not, then that's just what it is, and I kind of have to accept that. But again, with a little bit of civility, what's now happening is we're able to say, this is an important date. Are we able to exchange dates? You know, I don't want to lose any time with the children. I appreciate you don't want to lose any time with the children. So rather than you just giving me this date because it's important to me, is there an opportunity for us to exchange it? Would there be another day that's preferable to you to have them? You know, could you use the day off that day to go and do something else? And so these conversations can start to happen, but also it means that if the answer is no, the answer is no. And that's that. And it also means I can't now try to think my way, well, what would I do? And this isn't fair. It's like, no, this is what's written, because it also goes both ways. And now what we have to both think as well, in order to be more civil, is that it does go both ways. So if I'm sitting out here denying all special occasions, for example, whilst our order does prescribe my birthday, her birthday, the children's birthdays, what it doesn't do is it doesn't prescribe auntie's birthdays or cousins' birthdays or because that's just too many people. And what happens if you have another cousin and another, auntie meets someone else, etc. So it's just too much. So it protects us as a family. So with that in place, again, it means that when it comes to their birthdays, we already know what's happening. It's all fair. It's if it's with me, it's with me, and they get a little bit of time with mum, and vice versa. But if it now becomes someone else's birthday, an extended birthday or an occasion, we now have the opportunity to have a discussion. And the reason why this discussion is important is because it goes both ways. So if I need the favor, you bet somewhere down the line, something's going to come up for you where you would like me to extend the grace to you because it hasn't fallen on your day. So again, that is civility working with the order, but I think fundamentally the order is really, really important. And I say that again from a place where without it, it was a lot of arguments, it was a lot of tension, it was a lot of my rights, your rights, and quoting, and we'll, when we get to courts and all of this kind of stuff. And now, whilst it may have taken a while for us both to adjust to the order, it now really, really protects our time and really protects our peace, because it also has now enabled me to get back to life. It means that when I have the children, I'm with the children, but in my diary, in my schedule, I can also say to my family, say to my friends, say to my workplace, this is when I'm available. This is when I'd like to do something. I can now consciously and wholesomely and peacefully get along with my life, knowing this is my time. And tomorrow we'll be back with the children. That's their time. And although that's not the life I envisioned when I had children, this is the life I have. And what that's doing is it's giving me a sense of balance as well. And like I said, if nothing else, it's really fundamentally taking out the war aspect, the argument aspect, the tension, because now the order is something to fall back on. So when we disagree, and there are dates that we can disagree with, that it just comes up. And as you know, when you're looking 6 months, a year into the future, and you're trying to make a plan for a date, or someone said, it can be hard to work it out. So when we disagree, it's something we fall back on, and there's a piece about that. It's like you've just got to let it go, or that's your win, if that's the case. And that goes both ways. And so again, the importance of that order is that it will just remove any ambiguity about where the children will be and the potential future for the kids. So if it's something that you don't have, then I would first say seek it out. I think you need to fill in a C100 form. Essentially, this is on a government website, so go check out the C100 form. It is on the Mesimen website, by the way, mesimen.com, under the resources section, which is another great resource, a place for resources if you're going through this, and a place to kind of get some other help if you're actually going through this. But the first thing is to actually get yourself into court. Now, there may not be I think there is a small fee. I think it might be up to £300. So I appreciate that if you're going through tough times, another £300 is still a lot, but as soon as you can raise that, get that done. The court system right now is massively delayed. They'll tell you it's COVID, call it what you want. I think it's always been delayed, but now you can expect hearings 3 months if it's an emergency, sometimes within 2 weeks if they call it an emergency. But the likelihood is that it's going to take 6 months, sometimes 9 months. I remember when I applied, it was January. My actual order came into place on the 4th of October. So that's 10 months later. And that was 2 hearings later as well. It's not always just 1 hearing. So keep that in mind. There is still a process after the day you've applied. Keep in mind that it is a childcare order that you want. If right now, for any reason, you're a parent who's not getting 50-50 access and you want that, and perhaps there's good reason as to why you're not getting it, then the process might be slightly longer. An organization called CAFCAS gets involved, and that's simply for the children's interest. I would argue that CAFCAS aren't always the most I don't think that their process is always the fairest. That being said, I think that they have so many cases now that they have to just do their best to have a report. Now, whether that report is accurate from both accounts is questionable, but it's something that they're trying to do in order to at least have done some sort of due diligence in terms of protecting the children and making sure, they're not putting the children with an axe murderer, for example. So there is process to this, and it can be quite long. If you guys are civil enough, then just go ahead and do it. You don't actually have to go to court. You can just get a solicitor involved and they can draft one up, write one up. A court will have to stamp it and agree it to make it a legally binding document. But it doesn't have to be done under duress. You don't have to, fight your entire way to this point. Of course, if you're dealing with someone that's totally unreasonable and will not talk to you or progress your relationship with the children, and you genuinely have a right to parent that child, then crack on, do it as quickly as possible. It can be really long, it can be drawn out, it can be emotional, and it can be costly. Let's just be very clear. When I did it, I took a solicitor. I wasn't messing around, and a barrister to the hearings, and that, just say that is more than a year's salary. It's a lot of money. And that was, when you think about it, 2 hearings and a lot of email exchanges between both myself, the solicitors, a couple of phone calls, and predominantly my solicitors and my ex-partner. So it can become costly. Obviously, what they were trying to do was trying to get her to just agree to the order before we had to go to court. But non-compliant, and if someone is being non-compliant, then I would argue don't waste money on it, because it's just, they will wait, their bill, your bill will go through the roof on their getting off on cussing you out. So don't do that. Withdraw from that immediately and just wait till your hearing date. Make sure you're prepared. Go with all your documents ready. Be prepared for them to, what a court should do, by the way, and I'm speaking to fathers now specifically, because there is it is slightly weighed in this particular ecosystem. It is weighed slightly different, mother to father. So if you're a father who's waiting for this, then, go prepared, be prepared to, what a court should do on the basis that there aren't any safeguarding issues, is that they should now be advancing fathers' involvements with the children's lives, in that most courts now, by default, are trying to endorse 50-50. That's not always the case, because there are so many different circumstances, but that's what their default is trying to endorse. So keep that in mind. Also keep in mind that if you haven't read it, the Child Act of 1986 is fundamental to your ability to go in that court knowing exactly what the law says about your right to parent those children. And the reason why that's important is because I remember sitting in, I think, the second hearing, and basically my barrister shut it down, right? Because she quoted something, and I can't remember, I wish I could tell you, but she quoted it from the 1986 Child Act, and she quoted it as, if you cannot prove X, Y, Z, under the law, you cannot deny this father 50-50. That shut it down. And if I had gone in there first time and just said that, I wouldn't have been countless of thousands of pounds out of pocket. But what I'm saying is that, and again, you can't just do that, but it is really fundamental that you try to get an understanding of this. If nothing else, shortcut it by asking ChatGTP to summarize it to you as a 10-year-old. And if you want to, prompt it with something about your case specifically that it might be able to relate something back to you, because that will just give you a sense of, okay, this is what the law is. Now, just because it's the law doesn't make it enforceable immediately. That's the problem, right? So whilst you might have a right to parent those children and you have a right to 50-50 and there's no safeguarding concerns, the problem is that the law, if you just bowl round there with your quote in the law, you could still have the police called on you just because you did that. Do you see what I mean? So you have to be very cautious, very mindful, very patient. But again, if that's not all the case and it's a bit more civil than that, then wonderful. But I think just getting this on the go, seeking out that document, just really protects the children. And it also, finalizes essentially where they sleep. And I think for them, provides them with a sense of stability as well. Because they just know, my daughters now go 2 sleeps with mummy, 3 sleeps with daddy. 2 sleeps with mummy, 3 sleeps with daddy. 2 sleeps with daddy, 3 sleeps with mummy. Do you see what I'm saying? They just know. And to us, that changes in the summer holiday because the order has prescribed for that. But it's like, that is really important to me and to them. And again, it gives me the balance of, right, this is my time off, this is my week off in the summer holiday, versus, right, you better get to planning because you got 2 eager, energetic young minds to get through the next week. So you better have activities planned. Do you see what I'm saying? Even that for like my dinner times, when I'm cooking for myself, when I'm cooking for the girls, it's just good to know. And it provides me with a sense of peace and me with a sense of stability. Lastly, when you are a parent and you have to work, which of course most of us do, right? Just keep in mind that this, again, will help you with that, particularly with your employer. It's good to know when you're going to be available for the early meetings versus when you've got to go do a school run, when you're going to be available to, fly to wherever for your work do or whatever. Do you see what I mean? Even for you, your work schedule, it gives you a sense of, cool, I'm going to have to be here with the children at this day, school event, whatever, school concert, whatever, university graduation, whatever, driving lesson, whatever, versus, cool, I got a bit of me time, perhaps me and my new partner time, new kid time, whatever. But it's good to have that because it creates routine. And for children, however young, however old, it's good to have routine. It's good to have a sense of, I know when I'm seeing mum, I know when I'm seeing dad. And when you can have that and have a sense of peace about that order, I think, as a parent, that goes a long way, a very